Hi, I'm Lauren, and this is Ashley, Michelle, and Nicole, and we are presenting Adler v. Ontario. So we created a few questions for the class. Our first question would be, is it a violation of equality rights for public and Catholic schools to receive provincial funding?
Yes. No.
And our second question is it a violation of freedom of religion, section 2A, for only public and Catholic schools to receive provincial funding?
Yes.
And these are now our facts. Okay, so to get you all caught up with what's going on with our case, the first appellants that we're looking at are collectively called the Adlers. There are multiple families, but they're all called the Adlers under this. Due to religious reasons, they decided to send their children to independently funded religious schools. The Adlers believed that there was a violation to their rights under Section 2A of the Freedom of Religion and Section 15 Equality Rights, stating that the public and Roman Catholic schools are the only schools to receive public funding. Our next appellants that we're going to be looking at are collectively called the Alersmas, and they're consisting of 4 families. They have children with special physical needs, and they want to send them to another school, but because there is no public funding for schools, they wish to send some of their children they have to be forced to send their children to Catholic or public schools. And under Schoolhouse Support Services Program, those schools are funded. However, the schools that they wish to send their children to are not funded under the Schoolhouse Support Services Program. So both of the Alersmas and the Adlers were going after declarations that what was happening to them was unconstitutional and an infringement upon their rights.
The issues are, does it infringe or deny the equality rights under Section 15 for public schools and Catholic schools to be funded, but not other independently run schools? In addition, does it infringe or deny the rights of these people under Charter Section 2A, freedom of religion, to deny funding to these other schools? If the answer to the above question is yes, then is it legitimate under Section 1 of the Charter? In addition, does it infringe or deny their equality rights under the Charter, Section 2A, to have special school services funded for the Catholic and the public schools only? And if the answer to this is yes, would that be covered under Section 1 of the Charter? Okay, now we have the laws.
So the laws that we have in our case there's quite a few of them actually, but the main focus in this is the Charter rights that were violated. So Section 1, as everyone knows, is the Canadian Charter of Rights and Freedoms that guarantees the rights and freedoms set out in the Charter. And we have Section 2A, which, as was just said, is the freedom of conscience and religion. Section 15 and 23 and 27 are also large issues stating, going along with 23 is the first language that was learned, and it's required under this charter. So going along, we also have the Constitution Act of 1867 and the Constitution Act of 1982 and the Education Act. We also have the Health Insurance Act, both regulations, and we have the School Act.
So from the 1867 Constitution Act, it is stated directly, no law may prejudicially affect any right or privilege with respect to denominational schools which in any class of person had at the time of union. The effects of this subsection is to entrench constitutionally a special status for such classes of persons, granting them rights which others are denied. Now, Section 93 of the 1867 Constitution also gives the provinces plenary powers with regard to education, although there are restrictions upon that. Well, there are many cases presented during the trial The only really important one, the one that actually made or broke the case, was Section 93. It was the most powerful argument, and it was created to minimize the religious problems at that time. It was created to protect the rights of the Roman Catholics in Ontario and the Protestants in Quebec. And as such, Protestant schools are funded in Quebec and the Roman Catholic schools are funded in Ontario. These religions have protection because they were the only religions at the time of the Confederation. And with regard to that, they are the only religions that are funded. Now, I already mentioned that the provinces have plenary powers, but the public schools were a compromise at the inception of Section 93, and we found that these are all valid arguments against the appellant's allegations of freedom of religion and the equality infringements. Since it's not an infringement of rights to deny the appellant's funding for education, then it's obviously not a right to deny them funding for additional educational or special services. And the bottom line is, what was found is that Section 2A and Section 15 cannot be used to overwrite the Constitution. And we do have another quote, as per Wilson J. It was never intended, in my opinion, that the Charter could be used to invalidate other provisions of the Constitution. And with that said, the appeal was dismissed, although McLaughlin J. and Lahiro Dubé J. both dissented in part. And now we have our opinions.
So with this case, our opinion is that we believe that the laws are the laws and that they must be followed. However, that we support the decisions, we feel that there's more to this case. We believe that offering medical services is not the same as what the case is referred to as educational support, and that all school children should have access to necessary medical care. Since the province has plenary powers, perhaps there might be a way to persuade the Ontario government to approve the funding of medical services in all of the schools. And that brings us to the end of our presentation. And is there any questions from the audience?
No. You might want to look back, because what I just noticed is that your head was cut out by the foot. So some of us might not actually be in this. That's what